So welcome everybody to our February, the end of the month ABM talk. As most of you, or at least the regular participants may know by now, my name is Ludwigs, and I lead a DFG project entitled Seeing Antisemitism Through Law for 2 years, or almost 2 years now, at the University of Gießen. The overarching goal of this research is to comparatively examine links between the legal form and antisemitism in 4 different European countries. We have the UK, Poland, Germany, and France. In our ABM talks, we offer monthly, last Thursday of every month at 4 p.m. Central European Time, usually still online talks on anything that deals with law, anti-Semitism, and seeing, obviously all of our emotions included. Our time is shorter today because our commentator, Professor Christoph Möllers, needs to leave earlier due to prior engagements or family engagements. So I will be brief in introducing both our guests, who luckily do not need much introducing. And then just give a couple of words on the topic so that those of you who do not live or have not lived on planet Germany last summer may get a better picture of what this talk is all about and its importance. So it is my great pleasure to have Professor Ralf with us today to speak for about 25 to 30 minutes about artistic freedom as an excuse, the anti-Semitism debate at the Documenta 15, between art and law. Ralf is the director at the Max Planck Institute for Comparative and International Private Law. He is a chair in global law at Queen Mary University of London and a professor of law at the University of Hamburg. It is also a great pleasure for me to have Professor Christoph Möllers comment on Ralf's talk for 10 to 15 minutes because of course, his personal and official engagements with the Documenta 15. Professor Möllers is a professor of public law and philosophy of law at the Humboldt University, Berlin, and permanent fellow at the Wissenschaftskolleg in Berlin. So just a bit about Documenta 15. The Documenta 15 took place from 18th of June to 25th of September under the artistic direction of the curatorial collective Rangrupa. Even before the beginning of the exhibition, the appointment of the Indonesian curatorial collective Rangrupa as an artistic director was a cause of some concern. Fears were voiced that anti-Israel and anti-Semitic positions are to be expected at the Documenta 15, as some of the curators and the artists invited by them were known to be close to the BDS movement. The executive board of the Documenta reassured the public that anti-Semitism would not be given space at the Documenta. Still, the opening weekend of the Documenta 15th, on the 20th of June, 2 anti-Semitic depictions were found in the work of People's Justice by the Indonesian artist collective Taring Padi. The executive board acknowledged anti-Semitic nature of the work of art and advocated for its removal. And also the collective Rangrupa apologized. What ensued were weeks and months of controversy. More anti-Semitic artwork was found in the exhibition. There was a back and forth with regards to consulting an external expert advisor on anti-Semitism, a hearing at the German Bundestag, consistent criticism by Jewish organizations. The artist Hito Styril withdrew her artistic contribution from the Documenta, the laying off of the head of the executive board, and the formation of a scientific expert committee that examined the pieces of art in question, with Professor Möllers being one of their advisors. Documenta 15 did not close, but remained open until its final day in September. It nevertheless left a huge mess that we're now still dealing with. Just a couple of questions. What duties do public authorities have when dealing with anti-Semitic art? When does the state censorship of art start, if it starts? What role do definitions of anti-Semitism play in the curation process, etc.? So without further ado, I give the floor to you, Professor Michels. The comment will, so Christoph will follow with his comment, then you'll get the floor to comment on his comment. And then we will open the floor for Q&A. At this point also, we will turn the video and the microphones of the participants for the Q&A and turn off the camera that we're now recording. So we've been Zoom bombed last year by neo-Nazis, and it was a big mess. And so darkness appears to be the safest measure right now. So I apologize in advance. And yeah, without any further ado, the floor is yours, Ralf. Go ahead.
Thanks, Rayut. Darkness, of course, was the response to the anti-Semitic artwork as well when it was concealed. So I guess that's about fitting. Thanks very much for inviting me. Not only that, thanks also for the really fabulous and important project that you're doing. Half thanks only for insisting that I speak about Documenta, because I had hoped for a slightly less controversial approach, but I'm at your service. Full thanks, of course, to Christoph Möllers for being willing to comment. When I suggested him, I didn't realize that he was writing an expert opinion on many of these topics for the State Minister of Culture. So in many ways, it might seem more appropriate that he would give the presentation and I would only comment. I just heard that I have a right to re-comment. I'll downplay the many agreements that I have with his expert opinion and point to one point in the end where I see a logical problem that he sees that I don't see, and maybe he'll be able to respond to that. I'll come to that then in the end. When I say this is a controversial topic, I realize that because it took an unusually long time to prepare for this talk, because there's so much that can't be put into it. There would be far more to be said than in the 25 or 30 minutes that I have. And so I'll try to focus on only a few points and leave others possibly for discussion or for another occasion. I'll try to share my screen, right? Because I have a number of beautiful pictures, as one does these days. And I do have a lot of pictures, because a lot of what I'll talk about will actually be preliminary to the question of how to deal with anti-Semitism. It will deal with the question, was there anti-Semitic art, or how clearly was there anti-Semitic art, or to what extent was the anti-Semitism in the art or somewhere else. So, but let me start. The title for the presentation picked in the 30 seconds that one spends on that was derived from a conference that was held in December in Berlin that has this title, Artistic Freedom as an Excuse. And when I saw the title, it seemed puzzling to me, because artistic freedom would not really seem to be an excuse in any meaningful sense. Artistic freedom is a right, it's a basic right, so it provides a space within which one is allowed by law to do certain things, but of course thereby not justified to do those things in other ways. So if there is a right under the Constitution to engage in anti-Semitic speech and art, and indeed there is, that is obviously not in itself a justification to do that. So one thing that seems puzzling to me here is how it seems to conflate responsibility and legal spaces. And the second is also, and that became clear later to me, an excuse for whom? Who is being excused here? Is it the question of the artists who seem to be able to do whatever they want? Or is this in fact an excuse for the state to not interfere with what it sees as anti-Semitic art? And I think it's the latter where much of the problem and much of the conflict lies. And that creates a more interesting question. Why is this a difficult question? Well, in part because if we take the three elements in seeing anti-Semitism through law, right, the seeing for the art, anti-Semitism and law, then those are very different disciplines, right? In law, in art, we often have multiple meanings and unclear attribution, meaning that first, an artwork typically does not clearly mean one thing. And second, with the death of the author, death of the artist, it is not clear that whatever meaning is to be read from the artwork is attributable to the artist or indeed the curator who picked this. That's a very different way of engaging with art than what we know in law, of course, where typically for legal provisions, we look for clear meanings, and when those are state rules, we clearly attribute those to the state. The third element in that, of course, interpretation and meaning and anti-Semitism research stands somewhere in between, because of course we have scientific ways of determining what should or should not count as anti-Semitic, but at the same time we have wide discrepancies on the determination what does or does not count as anti-Semitic, and that is certainly has been very visible in discussions about Documenta as well. So it's within that kind of conflict that my topic really arises. What I want to ask is, first, what was the scandal about? And the normal response is to say twofold. First, there was a lot of anti-Semitic art, as Reo just said. And second, there was insufficient institutional intervention, or more generally, an insufficient institutional response by the governing institutions of Documenta. And second, from that comes then the question, what is the proper legal response for the state? One would be to say to remove anti-Semitic art. The second would be to say we don't remove it, but we contextualize the art, we provide context, and we distance ourselves from that as the state. And thirdly, and I borrow this from Christoph Möllers because it's a nice formulation, the liberal scandal of the constitutional order, some way in which perhaps anti-Semitism is there and the state does not or cannot interfere. I'll come back to that towards the end. Now, the first, when I looked at this, there was not that much material, but since then, of course, two important documents have come out. One is Christoph's aforementioned expert opinion for the government on the conflicts between the state's duties and the artist's rights in the realm of financing of art, but in particular with regard to controversial art, anti-Semitic content in particular. Christoph focuses a lot on parallel here between anti-Semitic and racist elements, but racism questions have been almost completely absent in most of these debates. And the second document, of course, is the final report of the scientific committee. I will draw on that a little, but the report is long and deserves a much more comprehensive response than I could give today. And so I'm not going to actually respond comprehensively to that, except to take the report as one formulation of some of the problems and some of the possible responses. Now, I want to look first, where was anti-Semitism at Documenta? Was it in the art, or indeed was it in large part somewhere else? Because that's important before we know how to respond and how to regulate the scandal. Like in general, in law, unless we know clearly what it is that we want to regulate, we can't properly know what it is, how we should regulate, how we should respond. And I would think that the formulation that we find almost universally to say the problem was anti-Semitism in the art is severely too narrow. I think the problem in the scandal was much broader, and that means that the responses that we have to find also have to be much broader. And I'll come to that a little towards the end. But let me start first, where was anti-Semitism at Documenta? Was it in the art? And I would say it was mostly not in the art. Mostly the art at Documenta was not anti-Semitic, at least not clearly anti-Semitic. That is, of course, counterintuitive, because the entire narrative that we've seen was to say that art was anti-Semitic. Indeed, Documenta was characterized, if you want, by the ubiquity of anti-Semitic art, at least in the public discussion, less so perhaps for people who went to see Documenta. But if this is my claim, don't take my word for it. Take, in fact, the executive summary of the final report of the scientific committee, which says that 4 artworks, and that's 4 out of 1,500, 4 artworks of Documenta refer to anti-Semitic visual codes. I'm not exactly sure what that means, or transport messages that can, respectively, must be interpreted as anti-Semitic. So this is 4 artworks. I think the number is possibly 5. I wasn't exactly sure. It doesn't matter so much what the numbering is. But the focus that I have here on can, respectively, must is the one that is really puzzling, at least to a lawyer, because, of course, can and must are worlds apart in terms of what they mean. To say you can come along and visit grandma is very different from you must come along and visit grandma. And so I am not exactly sure what can respectively must means here, except to think that it is probably the formulation of a compromise within the committee. If we look at these artworks, those are the ones that I want to focus on and to see how they play out. You can see two artworks which, according to the committee, must be read as anti-Semitic. And I think that's certainly right. One is the Jewish vampire with fang teeth and SS runes on his hat that Reut already mentioned. That is on Taring Party's People's Justice. It is a grossly, disgustingly anti-Semitic image. It's hard to imagine an image that would be more clearly anti-Semitic. And that is one of those which must be read as anti-Semitic. That was also, as Reut pointed out, that was discovered, I believe it was discovered first by a visitor and posted online, and then was concealed, and on the next day the whole artwork was taken down. So this artwork in fact didn't stand at Documenta very long, and I think that's relevant, and I hope you'll see in a moment why. There's a second artwork that the committee believes must be read as anti-Semitic, and that's probably true as well, although that is also more complicated. This is from a cartoon, Prisons de Femmes, Algiers, 1988. This is a hook-nosed Israeli soldier who's being kicked in the gut there. And it's the clear anti-Semitic imagery in the way in which this Israeli soldier is depicted on the basis of stereotypical depictions of Jews. Now, why is this more problematic? Then the first case, one, it's more problematic because this takes place in an archive, right? This is some 35 years old, and it is presented as part of an archive. So the attribution is not as clear as it is in Taring Party, who were the artists. Second, this is in fact a text that, an artwork that was contextualized after criticism came up. The contextualization did not take place in the way in which critics wanted it to be. That is, first, the contextualization denied the possibility of an anti-Semitic reading of the work and did not distance itself from the anti-Semitism. And so the criticism is to say, first, the contextualization was incomplete. Second, it didn't acknowledge that there was anti-Semitism. Third, it didn't distance itself from the anti-Semitism. And fourthly, it did not conceal the actual anti-Semitic imagery in the way in which I try to do that here, at least to some extent. And the report makes the good point to say other archives had such powers. The so-called Black Archive indeed did conceal the racist image. So those are the two works that must be read as anti-Semitic. And there's a third artwork where I'm not really sure about what the assessment is. That is one that can be read as anti-Semitic unambiguously in the committee's view. So linguistically, this is somewhere between it must be read as anti-Semitic or it can clearly be read as anti-Semitic. This is Tokyo Reels. This is the film collection that was shown, a collection of old pro-Palestinian films, several of them propagandistic, several of them strongly critical of Israel. In fact, Reut pointed out, not even mentioning Israel by name, celebrating terrorism, so problematic in many regards. Here again, we have the issue that this is presented as part of an archive, and we do have contextualization there. And the criticism was indeed that the contextualization was again insufficient and there was no distancing from the content. This, of course, is the case where the committee came out 2 weeks before the end of Documenta and said a contextualizing text and the distancing has to be included in the exhibition or the artwork has to be taken down. Management refused that and said the artists might pull out of not only these artists, but all artists might pull out if we try to do this. And so in the end, a contextualization was put on a fence outside of this. Here you have a picture of how that hung there. I'm not sure anyone read that there. Of course, Tokyo Reel, also one case in which the view of this being anti-Semitic or not was not universally held, at least outside of the committee. Here's one position by a historian who says, yes, it has anti-Semitic elements, but we have lots of elements that are racist and problematic in all signs of the discourse at that point. And here's another suggestion to say that censoring an artwork like this is concealing the very real conflicts and imbalances that are shown in this. So as with many issues, there are discussions over this as well. So that's the one that can unambiguously be viewed as anti-Semitic. The fourth work that can be read as anti-Semitic, but only justifiably so. So we have very subtle distinctions here. This is Mohammed al-Hawajri's Cyclops Guernica Gaza, where he photoshopped images from the Israeli occupation into historic, well-known artworks from the European canon. Here's one of those examples. And why the ambivalence? The position taken, at least in the general report, is to say if Guernica is viewed as the concrete Basque city that was bombarded by the Nazis, then this is a perpetrator-victim reversal, because now the Israelis are put at the place of the Nazis, and that is peer viewed as a as anti-Semitic. At least I'll say, according to some definitions of anti-Semitism. Of course, we have such equations of Israel with the Nazis with some frequency in the Israeli press itself. Just last week, Haaretz had a big article to say the new government is the new Nazis or something like that. Another view would say Guernica stands as a universal code for suffering from war. And as such universal code, would then be an image that would not specifically equate Israelis with Nazis, and would therefore, for that reason, not be anti-Semitic. Although that's another claim that's made, this is still in some way anti-Semitic because it is very one-sided, because it presents Israelis only as perpetrators and Palestinians only as victims. So this is a work that can be read as anti-Semitic justifiably. Another one that can be read as anti-Semitic justifiably are further cartoons here from the Archives des Luttes des Femmes, because these cartoons are said to delegitimate Israel, demonize Israelis, and promote the medieval child killer myth, because we see a soldier there who's actually in the middle of that, who's actually killing, or a rifle that is actually killing a child, and that is said to invoke a medieval myth. So in that sense, then, we have two artworks that are clearly anti-Semitic and some others that could or could not be anti-Semitic. And we have a large number that are not. So even if you take all of those together in terms of numbers, that is not very much. And I would say it is not very much compared to other exhibitions, certainly exhibitions that are anti-colonial, where Israel-Palestine often plays a great role, but certainly most other museums as well. After one of the, you may have seen that one of the members, indeed, of the committee suddenly realized that their own electronic catalog of the Dresden Museum had about 200 artworks that had anti-Semitic content, and that were then taken down from that electronic catalog. So in a sense, some of this artwork is scandalous and shouldn't have been there. But even if you take all of those in, it is just not very much. And so the puzzlement on that sense is then, why exactly did this become so scandalous? Why did it become so traumatizing? And it was, the whole scandal has been traumatizing, clearly. It has been traumatizing for Jews in Germany. It has been traumatizing for the artists at Documenta. Why did that happen? So my sense is that in the focus on these artworks and the incredibly detailed focus that is taken on these artworks, we've fallen prey to two problems that are also relevant for the legal assessment. One is the framing of the debate. That is, the whole debate from the beginning was framed as one of Documenta as representing anti-Semitism. So this starts in January when a anti-Deutsche Zionist blog presents wide-ranging suspicions against artists at Documenta who would be anti-Semitic. Those have been refuted. I think they also didn't materialize. This was on a blog. This then came out in the Urbarone, which is a broader, more official blog, was picked up in the press. This is Die Zeit on 13 January 2022. It's interesting for me because on the right, it speculates on anti-Semitism at Documenta before anything has been seen. On the left, it praises Michel Houellebecq, says he's a reactionary author, but of course we have to be very tolerant of him. So we have a framing of this before Documenta starts. I tried to do a search here on some newspapers, how many of them mention Documenta and anti-Semitism before Documenta starts. And you see that's of course not very good empirical work, but maybe it's workable. You see Welt Online with 87 such articles that link these before the Documenta has started, before much evidence of this has been shown. Die Welt, another 16, Welt am Sonntag, another 15, some of the other big journals up there as well. The Jüdische Allgemeine, very little, in fact. So many of the claims to say that somehow Jews ran an attack against Documenta, I would say is mostly not true. Most of the attack on Documenta was run by the anti-Deutsche in Germany and by the general press, general newspaper. So this framing was there before Documenta started. We see that it had some effects in racist attacks on some of the artists, on which I would say more focus would have to be laid in retrospect as well. And of course, it appears remarkably in the opening speech of President Steinmeier, who spends more of half of his remarks here on the danger of anti-Semitism and anti-Zionism and criticism of Israel. He says there are limits to debate. He seems to imply there are limits to art. Before the first artwork has been discovered, of course. So the framing then was there, and if indeed no anti-Semitic artwork had been found, probably our response would be to say this all was an unjustified preliminary critique of something that didn't materialize. Of course, it materialized, albeit in different ways. That is, when telling parties people's justice is shown, and the anti-Semitic element is discovered, that has fairly little to do with the criticism that happened before. The criticism that happened before had to do with Israel-Palestine conflict. It had to do with BDS support. What we have here is the clear anti-Semitic imagery that has very little to do with that. But of course, it's close enough to fulfill the framing, fulfill, if you want, the confirmation bias. And of course, indeed, it's the worst thing you can imagine to happen after Documenta had promised that no anti-Semitic art would be shown at the exhibition. A remarkable promise made by the management at the time without obviously checking on whether that was actually true. And it turned out to be untrue. So what happened, on the one hand, the artwork was taken down almost immediately, as you see in my timeline below there. I think it's discovered late at night. I think the tweet comes close to midnight. Next day, quite immediately, imagery is concealed. Next day, the artwork is dismantled, so it's almost not there. Nonetheless, leads to the puns to say the whole Documenta is as an anti-Semita is completely defined by this. And people have said this has become the defining artwork of Documenta. And then, of course, the issue of Documenta and anti-Semitism is even more present in the press. In fact, at least in the German discussions of Documenta, I would say articles focusing on the anti-Semitism discussion far outnumber articles on any other artworks, with the perverse effect, if you want, that the most well-known artists from Documenta now are Tarim Padi, and the other perverse effect that Ruang Rupa, in fact, as curators have been determined as the #1 influential people in the art world, whereas all the other artists who showed at Documenta, whose art had nothing to do with any of this, were almost completely ignored. So what we found also, of course, after telling parties people justice had been found, was a frenzy almost, a frantic search for more anti-Semitic art at Documenta. And in some way, you could say the fact that only 4 or 5 works of such suspicion were found is certainly not due to a lack of searching, because tons of hobby anti-Semitism experts took pictures at Documenta and found all kinds of artwork to be somehow anti-Semitic in some way. So in that sense, I would say that a hermeneutic of suspicion that was enhanced, if you want, by finding people's justice clearly played a role here. One famous example, of course, is this. This is Taring Padi, All Mining is Dangerous. Is a part of that. So there's a long-nosed person with money on the left. And that, of course, looks clearly like an anti-Semitic imagery of a Jew. And it's then indeed found out that the hat was replaced. The original hat looks like this, so that must clearly have been a kippah. So they wanted to conceal that this is a Jew. And it turns out that all of that is quite clearly and quite easily not the case. The figure is a classical Indonesian wayang puppet, Petruk. You see Petruk on the left on this picture. And the hats are clearly a topi hajj. This is one Islamic hat worn in Indonesia that is then replaced by a songkok, another Indonesian hat for believers. There's even a video on YouTube where the artist explains that this is a spiritual man, clearly making clear that this is a Muslim who is really in there with the money. So it has nothing to do with anti-Semitism, except in the reception that we have once we're framed to see anti-Semitism in such artwork. Second example, one that I have 3 examples. Second example, late in the discussion, we have these posters come up, BDS being in Documenta as a struggle, which are read to be clearly supportive of the BDS movement. And I look at that and see, why would that be supportive of the BDS movement instead of just an ironic take on the constant presence of the topic of BDS in all of these debates? If I read this literally, it's not about boycott, divestment, sanctions. It's about being in Documenta as a struggle, which seems correct. And if we see other notions of BDS, like the license plate of Barbados, or indeed one that I like a lot, the homepage of the Federal Association of the Self-Employed, we also would not think that this is in any way supportive of the BDS movement. So clearly, reading this as supportive of BDS is a function of our particular interpretation of the artwork itself. And I would say this poster in particular is one with a deliberately ambiguous meaning. So it does what art often does. It plays with scandal, it plays with provocation without being clear about its content. The third, this is actually one example that I really like. This is the woman that you see who was kicking the Israeli soldier in the guts. And one of our foremost anti-Semitism experts immediately sees a holde blonde Maid, a blonde woman in this image. And of course, if you don't look closely, then that's what you see. That is, if you are completely under the influence of your German imagery. If you put it in the context of Palestine, you can see that this is a traditional Palestinian headcloth. And I know that because this very artwork is actually also one that was hanging at Documenta, albeit in a different room. So the point that I have here is, yes, this is the reading I take of this art if I use both my detailed knowledge of European imagery combined with the absence of knowledge of imagery elsewhere, and add on that the hermeneutics of suspicion, where I assume that these things are all likely to be anti-Semitic. That's the one point. The one point where I think anti-Semitism is produced in the reader, in the observer to some extent, and not completely attributable to the art. The second is what I want to call co-production, and that's actually one that has not been discussed, although I think is crucial in the debate. The core image, the Jewish vampire, the one that all of you know, so I can blur it and you know what the image is. I guess none of you saw that in Kassel, because it was not in Kassel. It was in Kassel for some 36 hours, some less, I guess, 20 hours, and then it was gone. So why do we know the image so well? Because it was reproduced everywhere. So this is in the Frankfurter Allgemeine. It's a very ironic take, right? Stefan Trinks says you have to take the image down, while at the same time, the same journal is putting the art up, right? So Fatz says, do not show this at Documenta, but don't worry about showing this in the newspaper. I have not seen anyone comment on this really strange coming together. The only ones who realized that was actually Twitter, because Twitter banned the very tweet with which Thorsten Sommer pointed out the imagery. It said, this is anti-Semitic imagery, and if we want to ban anti-Semitic imagery, then we have to ban it also when someone shows it to point it out. So what do I mean by this? We have co-production of anti-Semitism, the constant bombardment that we had of this Jewish vampire, right? The constant re-traumatization that happened through the showing of that image was not due to Documenta, was not due to the artists or the curators, but was indeed due to the media reproducing the imagery and thereby co-producing the anti-Semitism. And not only outside, we had this really strange artwork here. This is Leonard Schmidt-Dominé, who brought the very Jewish vampire back to Documenta, he said with a good intention, because he wanted to protest against anti-Semitism, as though that was still necessary at that very point. That artwork was taken down, and some said this is censorship, this is dual standards. Why are you taking this down only when it criticizes anti-Semitism? But of course, it's exactly consistent standard, because People's Justice was taken down. And so this artwork is taken down as well. But the idea behind that is to say, some people do not have the right to show imagery that is anti-Semitic, and others do have the right to show it. Or you are not allowed to show anti-Semitic imagery if we're unclear about your intention, but you're fine to show anti-Semitic imagery as long as you have the right intention. And so one part of that quite clearly is that this is a fight over discursive hegemony in the production and co-production of anti-Semitism. It's a fight over discursive hegemony as to what questions matter and do not matter. I said we had disproportionate attention to the anti-Semitism issue over others, including racism. The second is the hegemony on who's allowed to present anti-Semitic art and who is not. Frankfurter Allgemeine is allowed to do so, but Documenta is not. The third, of course, is whose perspectives, interpretations count and whose do not. That is the specific German reading of this art, what is determinative or alternative readings. And the fourth is the frequent focus on saying what you had to distance yourself, you had to contextualize that. I'm calling this epistemic violence here because that's the language from decolonial theory. It is to say a meaning has to be attributed, imposed on the things that are shown. From a decolonial perspective, you'd say we have to be allowed to show things without putting them into such context, without imposing a reading on them. So in that sense, the duty to contextualize and to distance yourself from that is an interference with that as well. So much for the art. That was a long thing, but I think it was an important point to say the phenomenon that we had is much more blurry, because much of the art is not clearly anti-Semitic, and second, much broader. So how then do we deal with that from the perspective of law? Maybe I'll cut very short here because and give Christoph the chance to talk more about this. These are important points, but many of them are in his expert opinion. So I run through them quickly. They're important because they're underappreciated in the discussion. I think the first is anti-Semitism. Counterintuitively is protected by freedom of art and of speech. That is, both speakers and artists are not bound by and confined by the constitutional order, and indeed they are free to engage in anti-Semitic art and anti-Semitic speech. There are good justifications for that, but I won't go into that. Another thing that artists are free to do is that they do not have to provide balanced views of conflicts. So there's no duty in that sense for artists to say we have to be fair to the Israelis as well. We cannot only present Israelis as perpetrators, we also have to present them as victims. It is just not something that is not a proper limitation of their artistic freedom. Here's an example from the European Court of Human Rights that points that out with regard to the boycott and sanctions movement, which is protected speech under the European Convention on Human Rights. Second, you can limit this only by general laws. That is, you cannot limit with regard to specific content of speech or viewpoint. That is, regulation of speech and of art has to be viewpoint neutral. There's a slight exception that the Constitutional Court makes for the praise of National Socialism. But otherwise, the state can give space for art or not, but cannot pick and choose on the basis of viewpoints. I'm simplifying a little here, but that's at least the tendency. So the frequent claims to say the state has to ban BDS art is simply not there in the instruments. Third point in this is that if art is ambiguous and attribution of the meaning is ambiguous, then that is resolved in the rights holder's favor. So the ambiguity in the meaning, if an artwork could be read as anti-Semitic or not, the poster can be read as supporting BDS or not, assuming BDS is anti-Semitic, then the ambiguity is in the right holder's favor, and restriction is possible only when no non-anti-Semitic reading is possible, and the meaning is clearly attributable to the artist or the speaker. That's something that we saw in the recent Judensau decision in a slightly different context. And the fourth point is that anti-Semitism is not protected only where concrete rights are protected and are protected by statute, in particular the criminal laws. So in that sense, on the one hand, there's a very far-going artistic freedom that includes anti-Semitism. That's shocking. That is what Christoph calls the liberal scandal. And it is something that is not well appreciated, I think, in the general debate. It is also not something that is widely supported in the general debate, because, of course, we know about the dangers and the despicability of anti-Semitism. But it is, in principle, at least what the Constitution says, and without going into detail here, in principle, that's also the case for state-subsidized art. I'll cut a little short here for time. So where now comes the conflict? What's the conflict here? Here's the conflict that Christoph Möllers sees. On the one hand, the artist is free to engage in art in the way that they want. On the other hand, the state has a duty, and I think he's absolutely right about that, the state has a duty to combat anti-Semitism. And that creates a conflict, he says, at least at places where state-sponsored organizations like museums, like Documenta, provide a space for art. Because the state is not entitled to basic liberties, the state has duties, and that includes the shareholders, the Land Hessen and the Stadt Kassel, and it includes the management of Documenta. And then the problem arises, how do you resolve that conflict? And the answer here seems to be a complex balancing act, and the expert opinion is not fully clear on where to stop there. Beyond informal communication, a public distancing, I think Christoph Möllers' point in his part is to say the most severe means is putting such a distancing in proximity to the art as was intended for Tokyo Real. The other part that is probably, as a Deitelhoff's part says, this is at least this must be there, so possibly more intervention must be possible. Now, I would say that if we confine the problem to that of anti-Semitism, then we're already to some extent missing the breadth of the regulatory problem. But if I stay with that, I don't see the logic here. I don't see the logic here of saying here is a conflict, and I don't see at least a conflict on the level of norms. And I'm not sure, therefore, that the complex balancing process is necessary in this way, please. And let me try to explain briefly why I mean that. On the one hand, the artist's freedom from state intervention correlates logically with the state's inability of intervention. That's the logically other part. I'm not presenting this here in Hoffeldian terms, but that's essentially what happens. In a sense, this creates a freedom for the state as well. That is, the freedom that the artist has from intervention creates a freedom for the state from intervening, from having to intervene. And in that sense, the state can say, and should have said, that the art that is shown at Documenta is not attributable to the state. And even though the state funds it, it is not attributable to the state. And second, we do not have to justify the non-intervention on the basis of how anti-Semitic the art is, because short of criminal liability, we do not have to intervene. We cannot even intervene. And that's why it seems to me the fact that the management got an expert opinion seeing whether criminal laws were violated and said, once they were not, they had no power to intervene. That seemed exactly right to me. And the claim to say they should have done some, they had to do more, I think weakens rather than strengthens the state. Because the moment that the state has to make a complex balancing, which of the artworks are anti-Semitic, which justify which kind of interference, becomes a problematic slippery slope, because all of this is open for contestation and discussion, and not one, I think, in which the state has a very happy role to play. That's the first way in which I don't see the logical conflict there. The second is when, with regard to the duty to prevent anti-Semitism, that comes together with the duty that is inherent in the freedom to protect artistic freedom. And so the same thing happens here. There's no real balancing to say the duty to combat anti-Semitism ends where the artistic freedom of the artist lies. And so the state has lots of ways to combat anti-Semitism, but it does not have to do so by interfering with artistic freedom. So again, on that level, I don't see the logical conflict, except in the general sense that the liberal state sometimes has to tolerate non-liberal views. But that's, if you call that the liberal scandal, that's the general essence, if you want, of the liberal state and of the liberal constitutional order. And so, and I'm coming towards the end then in my brief survey here, if you want. Where's the conflict here? For the state, artistic freedom is actually not an excuse at all, but a concrete legal constitutional reason for non-intervention. This is not a bad excuse in the sense the state secretly wants to support anti-Semites or something that may or may not be true, but the liberal state cannot intervene in that sense. And for that reason, calling this an excuse seems strange. For the artist, this is not an excuse because the space that is protected from the state, of course, does not create a space protected from responsibility. To the contrary, it's the very fact that liberalism attributes that responsibility to the artists, to the curators, and indeed to society where these issues have to be resolved. They cannot be in that sense resolved by the state. They have to be resolved in society. And what's the state's duty then? Really to provide structures in which that debate is possible. And in that sense, some of the proposals in the report are good, but the debate would need to be much broader. I'm in my last 30 seconds, I think. So my claim would be to say the scandal was not even mainly about anti-Semitic art. It was generally about attempts in a difficult discussion on discursive hegemony. And the proper legal response would be the enabling of these discursive spaces, as they happened when telling parties people's justice was taken down after a long discussion, both public and among the artists, as happened in Kassel between Roland Rupa and the Jewish community in Kassel, as happened at some of the, as happens at the Hochschule für Bildende Künste here, where Roland Rupa is now visiting. And it's on that level that I think the response would have to be. And I'm sorry that I ran so long, even after cutting so much out. Thanks very much.
Thank you so much. And I found it so hard to tell you or to write you that you should cut it shorter, just because I know that you put so much effort into this, and I really wanted to, you know, give you that.
Special apologies to Christoph. I'm sorry about that.
Go ahead, Christoph. The floor is yours.
Yeah, thank you very much. Let me thank you very much for this excellent account. Actually, I think I've read this, listened to you. I've read your piece on Staatsräson, and I really like very much the work you're doing. There are not so many people who document that in that kind of really well crafted and scientific way. I will still, there's not so much contradiction, but there obviously is some. And I will just to make 2 points. The one regarding to the question of, is that a matter of framing or is there something else going on? And the second one with regard to the legal opinion and the question, is there any contradiction going on? With regard to the first, I would say, yes, I very much agree with the assessment of art, the art pieces. I'm a little bit deviating from that with regard to there's not very much, because I think, you know, this is not a quantitative question. You cannot, basically, when you have a depiction of what a mass rape in some exposition, it's only 1/100th of the exposed, you wouldn't say it's not so much. It's a qualitative question. And the qualitative question is somehow adding up to the point that basically, this is beyond Indonesia, the only political conflict that is depicted in the Documenta, the Middle Eastern conflict, and it's only conflicted from one side. So, and so there are elements in that that you somehow can criticize, and I would say that, and I would say a little bit more to that, that this not very much is perhaps a wrong way of quantification. Now, why is there a scandal? First of all, I think there is a scandal. I agree with much of what you said about framing ex ante. There was this inflection point when people were somehow anticipating anti-Semitism without even being able to know it, and that is still a problematic point. I would agree with you. Still, I would say, why is that a scandal? Well, first of all, I think Documenta has become victim of its own very triumphant self-description as being the national global thing. And so their claim was basically what is going on here is addressing all of Germany in a way, all of the world art system. So when something is going on, that is a scandal, because it's very much a very self-confident organization that secondly never really took care of its own national socialist history. You know, we have an amazing piece of research from the Deutsche Historische Museum and Raphael Gross in Berlin that was totally ignored by Documenta, that it didn't even show up to the exhibition. They totally didn't want to know that. That's very much, there's a long history of Documenta not being interested in things that are going on with regard to Israeli anti-Semitism. Now, the real problem seems to me, not so much the 4 pieces perhaps as such, but the curatorial approach to that by Ruan Grupa. And here I must say I'm really of a different opinion than you with regard to what contextualization and curatorial approach means. I think there's always contextualization. You cannot escape it. You can only make it implicit or explicit. And Ruan Grupa, and you can, on the other hand, you can always show anti-Semitic pieces. You can show Russian war propaganda, you can show anti-Semitism, when you do it with some kind of curatorial approach that says, I show you how propaganda works. I'll show you how bad National Socialism was. I'll show you something, the aesthetics of fascism. You can do that, you're totally free. But the curatorial approach of Ruan Grupa was very much saying what we did is actually we invited our friends, they are part of our struggle, we endorse what they do, we are a big family, and what they like, we like, and so on and so forth. And it was actually, despite their claims to build something independent, it was a very homogeneous, even aesthetically very homogeneous, very top-down organized thing that was totally orchestrated by Ruan Grupa. And so the things to say there is no context and we have to speak the objects from themselves, that is obviously a hermeneutic illusion, that they never speak for themselves, they only speak in context. And then you can wonder, is it an explicit or is it an implicit context? And the whole claim to have a contextualization was actually a claim to have a recontextualization of something that has been contextualized by Ruan Grupa in a very, very specific manner. So the problem is perhaps the endorsement of a very one-sided thing by Ruan Grupa and the lack of engaging with the German public about it, the lack of explaining anything, to the lack of saying, okay, we have a problem, we have a specific case in Germany, we have Jewish communities, we talk to them, and instead of that, basically counter-scandalizing the whole thing as an effect of censorship, and they talked as censorship even before the committee was installed. They stopped, every public critique of them was actually framed as censorship by them. So I must say, I see that the scandal, though it is dubious in the beginning, I would agree with you, in the way it worked out, and was very much fanned by the in a way, non-irritability of Ruan Grupa and the Documenta organization in somehow coping with the fact that a certain kind of unease maybe too aggressive, maybe not always deserved, somehow popped up in the German public in general, in the Jewish communities in particular, and so on and so forth. And the only thing we got from them is actually to say, you know, that is censorship, we don't talk about this. We are fighting for artistic freedom. And then you get a scandal, okay. And I must say that I still think that the two actors that are somehow responsible for that from the Documenta side is the curatorial approach by one group on the one side, and the other one, the Documenta governance that somehow did not even, you know, formulate a position of its own, but basically say we are the instrument, we're the instrument of the artist, which is neither by law nor by the organization of the Documenta actually a true statement. That would be my first point. The second point is about the conflict. You said, so is there any conflict? So very much my proposal in the opinion is in a way procedural one. So I'm not so much interested in the hermeneutics of definition of anti-Semitism and so on, but what is the division of labor between the different parties? And I think we have a division of labor in which we have actually three actors. We have the ex-ante actor of the policy makers, basically the Hessen Ministry, the BKM, and so on and so forth. And they have actually a lot of discretion, and they can basically say we don't get BDS any money because there is no right to get it. They have basically a political way of you know, saying we endorse certain kinds of cultural politics and others not. They're not totally at liberty with that, but they have much more discretion in making funding decisions. Then we have the artists. Okay, they enjoy artistic freedom, even if they are funded by the state, no doubt about that. And then thirdly, we have this kind of administrative part that is somehow taking care of a museum, of the Documenta, of the theater, and so on and so forth. And here, as a matter of fact, there's not so much discretion going on. There is, in a way, in most of the cases, they have just let the artists go. That is what freedom is all about, and I would agree with that. Still, I think it's not totally inaccurate to talk about conflicts here on the two spheres you were talking about. You said basically there is no conflict, there's criminal law and nothing else. But first of all, in Germany, we understand constitutional law somehow of a balancing of somehow conflictual, or not contradictory, but conflictual rights. And obviously, even the criminal law part is the result of that balancing effort. So there's no self-evident criminal law rule, but everything we do in criminal law is already somehow balanced against, you know, individual artistic or other freedoms of expression. So I think there is the conflict. You cannot reformalize that as being there's criminal law, there's the other thing, but the criminal law is the result of an effort that somehow introduces constitutional law. That would be the first point. The second point is, I still think, and we know that from private law, I'm not so sure that in general we would say that freedom of expression, artistic expression somehow absolutely ends with criminal law. You know, we know that from copyright law, we know that from many other things, that there are other limits to that. And one might wonder about at least a certain form of war endorsing propaganda that somehow is perhaps not criminally prohibited, but maybe seen as a political problem. I have no real theory for that, but I think that we have conflicting interests here that have somehow to be made explicit. And the same, and that would be already my last point, is with regard to the duty to protect. Again, I would say, well, the duty to protect is not something that you can say that is only taking place within the sphere of the state, but is that the case? You would say it addresses the sphere of the state, but obliges him to do something that might abridge the rights of others. So therefore, this is again, I think too formal a view on what is actually going on. We have duties to protect, and this duty to protect justify intervention into the right of third parties. Again, we would say we have something like, yeah, not a contradiction, but a conflict of interest. And there are different ways of framing that. You can say there is the limit by law, so there is no contradiction. That is the result. Or you can say basically the process, the constitutional reasoning process that is going on is actually one that somehow takes into account a conflicting interest or conflicting rights. And I think that would be the more transparent way to look at it, and a way that somehow makes clear how the argument is somehow evolving on the one hand, and the other one that makes clear that this is an ongoing process with all the, in a way, uncertainties that this kind of balancing issues somehow always have. Thank you very much. That was very short. I have to run out in 15 minutes. So
okay, perfect. So Ralf, your comment to the comment, and then we open the floor. Thanks so much, Christoph.
Thank you very much, Christoph. I spoke so long, I'll try to stick to 2 minutes. On the first point, qualitatively, I would say the one artwork was clearly scandalous, and that was taken down. So that artwork was extremely terrible that it was shown, and then the correct response happened. And I'm just not seeing that the other artwork comes up to that magnitude of qualitative scandal, but we may differ on that. I would differ on the assessment that all the art was about the Israel-Palestine conflict, because that's a consequence of selection bias. If you only look at those artworks, then that's all that you find. But most of the art was on other conflicts, right? And the other point to make that it's one-sided, as I said, yeah, it's one-sided, but I would expect that from much art to be one-sided. I would not come to an art exhibition with the expectation of it being both-sided.
Yeah, but you know, it may be both-sided. I don't mind that, but that is not a reason to censor it. But maybe one-sidedness can create a scandal. Where's the problem? Isn't that part of the liberal script too, that we have scandals? I think I don't see that as, you know, why can't people be scandalized by one-sidedness?
It becomes scandalized in the sense that expectations are raised against actors that may or may not be within their realm, right? The scandal was immediately two-sided to say not only against the artists, but also against an exhibition that allows such one-sided showing of the conflict, right? And in that sense, I mean, of course, the scandal is shown by the coming together of what is shown at the Documenta and how the responses are to that. I mean, that's if you want, that's almost trivial to say that. The way in which the focus went on the anti-Semitism issues as opposed to others, including racism issues, right? The same People's Justice image had a grossly racist depiction of an African-American with a huge penis that was not discussed almost at all. There was on Taring Party also a lot of, in fact, rape depictions, right? Homosexual rape was a protest by the German Homosexuals Association against that. Taring Party said, yes, we apologize for that. And that scandal went away. So there's a clear part in which I think this is what the focus goes to is a matter of that framing. I would think that that's important there. I'll say a word perhaps on your point that artworks never speak for themselves. Of course they don't. But my point was not that they speak for themselves, but that there was the idea that the state somehow has to impose a meaning on them. And that's the part that is the epistemic violence. It's not to say, let them speak for themselves. It's to say, we have to find some official definition of what they say and what they mean. And beyond that, on the top down and on the curatorial inability to communicate, etc., I didn't speak about that, and so I won't go into much there. I think that would take longer. The legal issue and the conflict issue, I think maybe we have some other chance to talk about that with more time. But I think to some extent we're talking past each other there maybe. Of course, there is this conflict as a societal conflict, because as a society, we want to provide rights. And as a society, we want to combat anti-Semitism. And that is clearly a conflict. Question is, of course, how and where and by whom is that conflict then resolved? And to some extent, yes, criminal statutes are, of course, the results of balancing. But because they are the results of balancing, they are then those very provisions on which we define the limits of artistic freedom, right? So because the balancing went into the formulation of the criminal law provision, we don't have to do a second balancing once we have the provision and say, now we balance that against something else. I mean, as I understand, this is much more your expertise than yours, but the reason the Constitutional Court says, unless we have these formulated limitations in legislation, and that is viewpoint neutral, unless we have that, we don't engage in balance. we don't start to ask, is this like a really bad opinion, or is it just a moderately bad opinion? And if it's really bad, then we're going into banning, right? Because it says if you want to do that balancing, you have to do that properly in the legislative process. And in that sense, and I'm talking to someone who's much more supportive of liberalism than I am, but I understand the liberal project to say, it creates different spheres in order to not fall into those slippery slopes between with more or less authoritarian intervention by the state. Right? It says that once we have these limited spheres, and you depict those quite clearly, I think, in your expert opinion, to say on the one hand, here's the state, and on the other hand, there's the artist. That is a good way of assigning relatively clear tasks to the respective actors. And as I said, it frees the state also from having to take a position on everything. So even beyond the constitutional argument, a lot of the balancing requirements that you make in the end, and intervention suggestions that you make for the state, all of those put tremendous burdens on the state, which the liberal state can't cope with very well, right? And in that sense, in order that structures this as more clearly separated spheres is actually, it's supportive of the state on the one hand, and it's supportive, I think, of a discourse that is not somehow determined and predetermined and nudged in some way by the state. Because, I mean, lastly, I always think that the real place where anti-Semitism has to be combated is in society, right? And it's not in the state, and it's not by the state. And in that sense, the more we rely on the state for combating anti-Semitism, the more we risk that is not happening in society.
May I just make three very short points as a rejoinder? As a matter of law, I would basically only say, yeah, I think we find common ground. I still think that criminal law is not the only limit to freedoms of expression. I think that is quite settled. So there is other limits. There are other limits.
No, that's right. Of course,
but as a matter of normative statements you made, I would just make two remarks. The one is, so what is the problem when a one-sided exhibition meets a one-sided scandalization? So, in a certain way, the scandalization, we're living in Germany, it's the land of the Holocaust, obviously we scandalize one-sided for many reasons. So is there a problem? I don't see it, actually, The public doesn't have to take care of any problem in the same manner. It's a free public, so it's one-sided too. And with regard to epistemic violence, I think that is a problem I have with Juan Grupa too. I think that is doesn't really take into account that we are living in a democracy. I must say that. I think the democratic community that gives its own comment through its representatives to a museum, gives its own comment. Is that violence? Why is, a private group like Juan Grupa, who is disposing of 42 million euros of taxpayers' money to create a huge space and to create a huge power, why is that not violence? But, some democratic process that makes up its mind is not. There's a legal point. I see that. That is the part of rights. But as a non-legal normative argument, I can't really endorse that. I think there is no moral high ground that somehow makes the democratic state violent and the artist somehow innocent. That is, I think, religion of art. That is somehow not really building what is actually going on in the art scene in itself. Thank you.
I'll say 15 seconds on that. The last, when I say it's violence, it's clearly violence. The state has the monopoly on violence, so it can do some of those things. But it is, in that sense, the imposition of a meaning is what we define in decolonial theory, at least, as epistemic violence. You can say this is justifiable because it has a democratic background behind it. But that's true for other violence that the state does as well. It has democratic legitimation behind it, and that's why the state does that. But I think that's on the level of justification. It's not on the level of whether or not this is violence. And it does make a difference, certainly, whether we have the state as an actor or the curators are an actor, because we have different obligations that we put on them. That's also my concern a little with your saying on the one-sidedness is somehow it's a one-sided exhibition, so they should expect nothing other than a one-sided scandal. Possibly. But the question then is for the state in responding, and also the experts committee in responding, to what extent do we take sides in this, on that side as well, right? To what extent do we go with that very framing of the response? So that's, as an observation of what happens in the discourse, that's probably true. But insofar as what do we take as the actual matter of concern that we're regulating, I think we have to take that broader context into account.